Hello everyone, welcome back to the video. I am Miss Sini and I hope that you all are safe and sound at your place. In the last video, we have dealt with the contract of guarantee and today we will be dealing with yet another important special contract, that is contract of indemnity. A contract of indemnity is one of the most important types of commercial contract. Several industries such as insurance industry rely on these contracts. This is because the kind of nature of this contract. They basically help businesses in indemnifying their losses and therefore reduce their risk. This is extremely important for small as well as large businesses. So let us understand in detail about what is a contract of indemnity. A contract of indemnity basically involves one party promising the other to make good at losses. These losses may either arise due to the conduct of other party or somebody else. To indemnify something basically means to make good a loss. In other words, it means that the one party will compensate the other in case of a loss. For example, A promises to deliver some goods to B for ₹2,000 every month. C comes in and promises to indemnify B's loss if A fails to deliver the good. This is how B and C will enter into a contractual obligation of indemnity. A contract of insurance is very similar to contract of indemnity. Here, the insurer promises to compensate the insured for his loss. In return, he receives consideration in form of premium. However, the Contract Act does not strictly govern these kinds of transactions. This is because the Insurance Act and other such laws contain specific provisions for the insurance contract. So now let us understand what is the object of contract of indemnity. The object of entering into a contract of indemnity is to protect the promisee against the anticipated loss. So, what are the parties under indemnity contract? There are generally two parties in the indemnity contract. The person who promises to indemnify the loss is the indemnifier. On the other hand, the person who loses the indemnifier promises to make good is the indemnified. We can also refer to the indemnified party as indemnified holder. So let's understand the example. In the earlier example which we understood, C is the indemnifier and B is the indemnity holder. So let us now see what is the nature of the indemnity contract. An indemnity contract may either be expressed or implied. In other words, party may create a contract as per their own terms. The nature of circumstances may also create indemnity obligations implicitly. For example, A does an act on the request of B. If B suffers some losses and A offers to compensate him, then implicitly creates an indemnity contract. So, what are the essentials of a contract of indemnity? First is the party to a contract. There must be two parties, namely promisor or indemnifier and the promisee or indemnity holder. Second is protection of loss. A contract of indemnity is entered for the purpose of protecting the promisee from loss. The loss may be caused due to the conduct of the promisor or any other party. Third is expressed or implied. The contract of indemnity may be expressed, that is by words or written, or implied, that is inferred in the conduct of the party or circumstances of the particular case. Fourth is essential of a valid contract. A contract of guarantee is a special kind of contract. The principle of the general law of contract mentioned in section 1 to section 75 of the Indian Contract Act 1872 are applicable to them. Therefore, there must be all the process of an essential valid contract. That is, parties must have consent, no misrepresentation, legally bind, consideration, etc. Now, number of contract. In the contract of indemnity, there are one contract, that is between the indemnifier and the indemnity holder. Now, there are some rights to the indemnity holder. Let us see what are they. When the party expressly makes a contract of indemnity, they can determine their own terms and conditions. However, sometimes they might not do so. In such case, the indemnity holder can enforce the following right against the indemnifier. First is the indemnifier will have to pay damages which the indemnity holder will claim in suit. Second is the indemnity holder can even compel the indemnifier to pay the cost he incurred in the litigating suit. Third is if the party agrees to legally compromise the suit, the indemnifier has to pay the compromise amount. Now, the difference between indemnity and guarantee. As in the last video, we have also seen that there are important differences between both the contracts. So, let us refresh what are the differences between the two contracts. So, now let us get into some frequently asked questions on contract of indemnity. First question. Which contract is similar to the contract of indemnity? So the answer is contract of insurance is similar to the contract of indemnity. Second, what can we refer the indemnified party as? So the answer to this question is we can refer the indemnified party as the indemnity holder. Third question, a contract of indemnity can either be expressed or dash. So the answer is a contract of indemnity can either be expressed or implied. Fourth question, what is the primary liability in indemnify lies on the indemnifier while in guarantee it lies on who? So the answer is when the primary liability of indemnity lies on the indemnifier, in the contract of guarantee it lies on the principal debtor. So let's get into the conclusion of today's video. Indemnity is a legal exception from the penalty or liability occurred during any course of action. Indemnification is a promise that usually a contract provision protecting one party from a financial loss. Thus, it is something stated as a requirement that one party holds harmless the other. So I hope that today's video helped you to understand the concept well, and I'll be back with another topic. Till then, stay safe. Thank you.